Good morning. This is immigration lawyer Kyce Siddiqi from Long Island, New York. And today we're going to be talking about the Violence Against Women Act, which is an immigration benefit, also commonly known as VAWA, which is an acronym for Violence Against Women Act. It's an immigration benefit in which enables somebody who is married to a U.S. citizen to apply for a green card if they satisfy certain requirements. Now, despite the name Violence Against Women Act, this is something in which men could apply to. I have had and represented males who have who have availed themselves of this benefit and who are entitled to a Violence Against Women Act petition. This is an immigration benefit in which was created for the purposes of helping immigrants who have suffered extreme cruelty or battery at the hands of a U.S. citizen spouse. So today we're going to be talking about 4 elements that you need to know if you are interested in applying for the Violence Against Women Act petition. Now, if you have a good faith marriage with a U.S. citizen spouse, we're going to be talking about the 4 elements. So the first element is a good faith marriage to a U.S. citizen spouse. We're going to get right into it. The second element, in order to establish a successful VAWA case, is that you have resided with the U.S. citizen spouse. Now, that sounds almost like the first element, that you have a good faith marriage with the U.S. citizen spouse. But again, not every individual that resides with someone has a good faith marriage, and vice versa. Not everyone who has a good faith marriage to a U.S. citizen would be residing with their spouse. There are some people that actually have a good faith marriage, but just never resided with their spouse. So this is very nuanced. First element, you need to have a good faith marriage. Second element, that you have resided with the U.S. citizen spouse. Now, I get people asking me, well, what if I resided 1 week with the U.S. citizen spouse and it was so unbearable? Well, believe it or not, 1 week is sufficient. Even one or 2 nights is sufficient. But as you would have to prove that. We're going to be talking about the evidentiary requirements later in this discussion. But I want to dive right in and talk about the elements. The third element is that you have good moral character. Good moral character is something in which an individual needs to establish. Now remember, these 4 elements that I'm talking about, the burden of proof is on the applicant. So you need to prove good moral character. And fourth and finally, most importantly, is proving either battery suffered at the hands of the U.S. citizen spouse or extreme cruelty. Now, let's talk about the first element, that you had a good faith marriage. This is proven, and I mentioned it earlier, the burden of proof is on the applicant. You prove it through documentation establishing that you have contemplated spending the rest of your life together, which is joint commingling of asset documentation, health insurance, car insurance, your lease if you have one, joint tax returns, photos, things of that nature. Other useful documentation would include if you have utility bills, credit card statements, things of that nature, IRS tax transcripts. And if you don't have any of that, definitely you want to include third-party sworn statements or affidavits. Now, for the purposes of the second element, that you've resided together, it's very similar in terms of documentation. For the first element, you're going to include what I just mentioned earlier, in terms of proving that you've lived together, utility bills. If you have miscellaneous mail addressed to the both of you, that would be very important. Joint gym memberships, joint Costco's statement, monthly statement, bills, things of that nature showing a common address. Third element, good moral character. Each state generally has a way in which you could get a certificate or some kind of police clearance or some kind of rap sheet showing that you don't have any kind of criminal record. And if you do have a criminal record, it doesn't mean that you don't have good moral character. This is where somebody would have to analyze whether if you've satisfied the requirement for good moral character. There are certain instances in which the applicant for Violence Against Women Act was arrested, and that arrest stemmed from defending himself or herself from the U.S. citizen abuser. So that's something to take under consideration. There are individuals that were arrested for some type of alleged misconduct, but it was in connection with the abuse that they sustained. So a arrest does not necessarily establish that you don't have good moral character. Keep in mind, though, that the burden of proof is on the applicant. Merely asserting that you have good moral character is likely not enough. Other things that would establish good moral character would be third-party affidavits, potentially documentation from religious or religious institutions, from pastors, imams, rabbis, things of that nature. So this is something in which needs to be, of course, attached with the VAWA application. Finally, and probably most importantly, is proving either extreme cruelty or battery. Now, this is something in which many people are in the mistaken assumption that infidelity is extreme cruelty. And that's not within itself a meritorious VAWA application. So suppose the individual was seeking to apply for VAWA because the U.S. citizen spouse cheated on her or cheated on him. Well, that by itself probably is not a meritorious VAWA application. Infidelity, unfortunately, is not something in which you can just base a VAWA application on. Now, if it's something more than that, we're going to discuss that, then we could potentially pursue VAWA if you see an aggregate things that I'm going to be discussing. For instance, economic abuse. What is economic abuse? Not letting the immigrant, not letting the applicant work, or isolating her or him. Sexual abuse, isolation, intimidation, threatening deportation, cursing the individual out in front of family members. This is extreme cruelty. If you take all of these things under the aggregate, making fun of the accent, humiliating her or him. Now, this is something, punching walls. There are certain instances where the U.S. citizen abuser didn't lay a hand on the applicant, but that doesn't mean that you can't apply for VAWA, because remember, it's extreme cruelty or battery. Now, if the U.S. citizen abuser struck you, well, that's battery, and that should be enough. If you have hospital records, a police report, domestic violence reports, well, that would be very important to include. But if there is no physical abuse, that doesn't mean you cannot apply for VAWA. It's extreme cruelty or battery. Extreme cruelty, as mentioned earlier, is looked at in the aggregate. Economic abuse, isolation, intimidation, minimizing misconduct. The U.S. citizen saying, well, I did this to you, but that's not really criminal. I threatened deportation, but that's not really criminal. And if you report it to the police, well, you're going to get deported because you're here illegally. Things of that nature is looked at in the aggregate. Very important for USCIS to know to make a determination. Speaking of which, how will USCIS know that? Well, one of the most important pieces of evidence, if not the most important piece of evidence in a successful VAWA case, is your declaration, is the applicant's declaration. This is your opportunity to indicate with detail the nature of your relationship, how you guys met, and what ultimately happened. How did the relationship fall apart? And explain in detail how were you subjected to extreme cruelty. Remember, there's no court in terms of applying for an affirmative I-360 VAWA case. There's no judge. It's a USCIS adjudicator who's very experienced and trained in identifying these kinds of cases. If you like this video, please hit the like button, subscribe, and we'd be happy to see your comments below. Thank you again. This is immigration lawyer Kyce Siddiqi.